Senate Judiciary is now in session. We're going to hear 462, removing cap on wrongful death loss of consortium claims. Senator Carson, welcome to your own committee.
Good afternoon, Mr. Chairman, and good afternoon, Senate Judiciary. For the record, my name is Sharon Carson, and I have the pleasure of presenting to you today for your consideration Senate Bill 462, which is relative to removing the cap on damages for wrongful death loss of consortium claims. Mr. Chairman, these caps have not changed, I believe, since the 1990s, and it's time that we take a look at them and to decide whether or not we even want to have caps at all. But this bill does remove the cap on damages for wrongful death loss of consortium claims. The bill doesn't change anything in the current statute, but the amount of damages that can be recovered by a spouse or minor child for the loss of enjoyment of their loved one's life if they were killed by the negligence of another. And again, I'd like to reiterate, these caps have been not raised in nearly 30 years. I think we all know that today's dollar cannot even begin to equate what the dollar was worth 30 years ago. In New Hampshire, we have a long tradition in the belief and trust in a right to trial by a jury of our peers. And at this point, Mr. Chairman, I'm going to conclude my testimony. There are others behind me who can explain how these claims are brought and can answer any questions. Thank you very much, Mr. Chairman.
Thank you, Senator. No questions. Have a great day. Doug Haynes. Hi, Doug. You look different today, but
Good afternoon, Chairman. And good afternoon, Chairwoman Carson, and members of the committee. Thank you so much for allowing me to testify today. My name is Holly Haynes, not Doug Haynes.
okay.
And
I didn't have my glasses down. I apologize.
I also have poor penmanship. I am here on behalf of the New Hampshire Association for Justice. I'm also an attorney at Abramson, Brown & Dugan in Manchester, where I represent plaintiffs who are injured by medical malpractice and other negligent acts. During my career, I've represented numerous estates and families of victims of medical and other negligence and wrongful death claims. I've also represented a lot of surviving victims and their families in negligence claims. And I can unequivocally tell you that the loss of a spouse or a familial relationship impacts New Hampshire citizens the same way, whether their loved one is killed by negligent conduct or permanently harmed and catastrophically injured by negligent conduct. What isn't the same is how the law treats their losses due to the cap imposed on wrongful death claims. This bill seeks to correct that disparity by removing the cap on loss of consortium claims in wrongful death cases. I'm here to testify in support of the bill, and I urge you to vote ought to pass at the conclusion of this hearing. Later in my testimony, I'm going to give you an example of the disparate impact these caps have on real families who've been injured by medical negligence. But before I do, I want to point out that this bill is extremely narrow in scope. It doesn't create any new causes of action that are going to increase the number of lawsuits that businesses or insurers are facing. It does not create any new classes of plaintiffs or additional people who can bring claims. It doesn't require any additional proof at trial that would increase litigation costs. It doesn't increase any elements of any claims. All it does is eliminate the arbitrary cap on damages for claims for loss of familial relationships. I'm sure during the course of this hearing, you're going to hear from insurance representatives and businesses who have concerns about increased insurance premiums and how it may drive business out of New Hampshire. I submit these concerns aren't well founded, though, because if loss of consortium claims are considered at all in premiums or reserves for insurers, which I doubt, businesses and insurers already consider them in general negligence claims where they are not capped. Because every lawsuit for negligence, if there is a spouse, is going to have a loss of consortium claim. Moreover, our Supreme Court has already ruled that consortium claims only exist as part of the underlying negligence in a claim. So it's never going to trigger any additional per-person policy limits or any additional claims under any regular negligence claim. At its essence, this bill just makes the wrongful death statute comport with existing negligence claims, and it eliminates the only existing cap on tort damages in the state other than for governmental immunities and volunteers. I'm not going to rehash the legal analysis that I submitted in my written testimony with the cases and statutes from other states. I want to talk to you practically about how these cases are brought in New Hampshire, what's happening in New Hampshire, what's happening in other states, the practical impact of this disparate impact this cap causes in wrongful death versus regular negligence claims, and the reason it's not going to have any impact on businesses, insurers, or insurance premiums. No one who testifies today is going to tell you there's frivolous lawsuits in New Hampshire. No one who testifies today is going to tell you that the costs of lawsuits have driven up insurance premiums. The reasons for this are threefold. New Hampshire is a very small state. Lawyers value their reputations in their communities, in their courts, and with opposing counsel. We don't bring claims unless they have merit because it's not going to benefit anyone. Second, the New Hampshire civil justice system works. The jury system guaranteed by our Constitution works. Jurors in New Hampshire take their civic duty very seriously. They listen to the evidence in each case, they listen to the judge's instructions, and they don't render runaway verdicts. You never see headlines in New Hampshire about multi-million-dollar verdicts, and that's because those are very, very few and far between. And if there ever is one, the judge has the discretion to reduce that verdict through remittitor. Finally, there are huge financial disincentives to bring frivolous claims, and that's why we don't do it. It costs a lot of money to bring a medical malpractice lawsuit or a wrongful death lawsuit. To get a case to trial, we will spend hundreds of thousands of dollars on expert witnesses to come and testify, on medical records, and if the case isn't meritorious and we lose at trial, we're going to eat those costs as a part of doing business, and our clients are subject to paying the defense costs, which is a risk that no plaintiff is willing to take. They aren't going to bring a claim that's unlikely to be successful. Second, the contingency fee method for payment for attorney's fees screens out non-meritorious claims because we aren't going to get paid unless we can get a recovery for our clients. And finally, we spend a lot of time and money screening these cases before they come. Our office probably pursues 1 in 100 of the cases that contact our office. Those are what we would bring forward for claims. And the reason for this is how the claims work in a traditional case. In a medical malpractice case that causes someone's wrongful death, we first meet with the estate representative and the surviving family members. After that meeting, we spend thousands of dollars requesting the medical records for the decedent, and we review them internally in our office. Once we do that and determine that it merits an expert review, we spend thousands and thousands of dollars in getting well-credentialed board-certified experts at respected institutions to review those. These experts nowadays, if you get them from reputable institutions, which we do, cost between $500 and $1,000 an hour just to review cases. If they're reviewing thousands of pages of cases, we might spend $10,000 just in getting a case screened, and we might decline the case after that. These cases are not cheap. There's no way we're going to be bring frivolous claims, and we're going to file suit only if that medical expert can support the negligence claim. An important point to note is that there's never going to be a loss of consortium claim unless there is an underlying negligence or medical malpractice claim or wrongful death claim. The damages in these wrongful death claims are then limited by statute, and most are tied to the economic losses to the estate. The only damages a jury can award in a wrongful death case are conscious pain and suffering when a victim dies, before the victim dies, the medical bills and funeral expenses they incurred that caused the death, the duration of life and the lost years of life that the decedent lost, the lost earnings and earning capacity of the victim, and the loss of comfort, companionship, and society of the deceased. In many cases, the deceased is killed instantaneously during a medical procedure, so there's not any conscious pain and suffering that can be claimed as damages. In those cases, medical bills are similarly limited because the medical bills end at the time of the plaintiff's death. In cases where the decedent is unemployed or a homemaker or retired or disabled or handicapped, the lost earnings and lost earning capacity claim may not exist. And because of that, the loss of the person's life, The loss of their comfort, companionship, society, and familiar relationship are often the only damages that can be claimed in these lawsuits. When they're capped at $150,000 or $50,000 for kids, that's the legislature effectively telling New Hampshire citizens that this is all your spouse or your parents' life is worth. And that can't be the value that we place on the life of a person's partner or spouse. If their spouse was rendered comatose from a negligently inflicted brain injury, their recovery would be unlimited. It shouldn't be any different for someone who loses their spouse to death. I ask you to consider that wrongful death claims, too, are very few and far between. They're far fewer than regular negligence cases. And of those cases that are brought for wrongful death each year, there are even fewer that have surviving spouses and children. So this loss of consortium claim is a very minor subset of all civil actions that are brought in New Hampshire, and we shouldn't limit the damages that are brought in death cases, which are the most serious and catastrophic losses that someone can sustain. In each case where our Supreme Court struck down damages caps, it agreed with this, and in the seminal case of Carson versus Moore in 1980, the Supreme Court made clear that recovery of only a limited portion of damages cannot be the equivalent of recovery of such damages in full. And society can't escape its responsibility to provide justice by simply eliminating the rights of its citizens. New Hampshire law hasn't kept up with this principle or modern times with the caps on damages. I want to tell you what's happening in other states because I know that's something that's very important to the legislature. We're the only New England state that has a cap on damages for wrongful death of less than $1 million. Vermont, Massachusetts, Connecticut, and Rhode Island have no caps. I submitted most of these statutes with my electronic testimony. Maine is the only other state in New England with a cap on wrongful death damages, specifically for loss of consortium claims, and it was raised to $1 million in the 2023 legislative session in Maine. The state of New York prohibits damages caps completely on wrongful death cases in its constitution. And our federal court in 2011 recognized that New Hampshire had not kept up with its fellow New England states or the majority of the nation in Lacalade versus Loyne and Champs Carr. In that case, Judge DeClerico observed that New Hampshire is lying in the backwater of the modern stream for damages in wrongful death cases. When given the choice to apply New Hampshire or Maine's law in a case where either could be applied for damages on a consortium claim in a wrongful death case, the judge applied Maine's law, which was then a $500,000 cap. And doing so, the judge said the court finds Maine's wrongful death damages law is better calculated to serve the total ends of justice than the competing law of New Hampshire. It was very critical of the fact that our caps have not raised in years. It's telling if our federal court will not even apply New Hampshire's law because it's not going to serve the end of justice. Now, an example of a practical application of how this damages cap has a disparate impact on plaintiffs, I'm going to give you a summary of two cases that I brought. One case involved a 41-year-old Navy veteran. She was married for 20 years to her husband, and she had 4 children who she homeschooled. 2 of them had special needs, 1 had severe autism. The mother suffered a back injury. She went to our VA medical center for treatment, and despite her being opiate naive, meaning she didn't take opiates regularly, they threw pain medication at her. They threw a fentanyl patch on her one day. The next day, they tripled the fentanyl patch on her. They discharged her home the day after that with prescriptions for morphine and OxyContin, along with the fentanyl patches. And she wasn't tolerant to this. The wife and mother died of an opiate overdose, and 2 of her sons found her in her bed, passed away from this over-medication error. The children at the time of her death were 9, 11, 15, and a 17-year-old who was just 10 days shy of his 18th birthday. Had she passed away 2 weeks later, he would not have had a claim at all. There was no wage claim to be made in that case because she was not employed. She stayed at home with her children and she homeschooled them. In that case, and this gives you an idea of the types of arguments that our families, our clients have to listen to at trial and in depositions, the defense economist for the VA had the audacity to testify that the VA saved her family money by killing her because over her lifetime, she would have consumed more family resources than she was bringing into the family. They testified to that in a deposition, and shame on them. Shame on them for doing that. I don't think that anyone in New Hampshire would ever accept that argument. The husband in that case was limited to $150,000 for the loss of his wife and partner of 20 years. The children were limited to $50,000 each for the loss of their mother, their teacher, their mentor, and friend. The oldest son would have gotten nothing 2 weeks later. This isn't full and fair compensation for the loss of a wife, a mother, Navy veteran. This family lives in Amherst, which I understand is your district, and they still grieve their loss to this day. The second case, which is different facts, but similar application, was a regular negligence case, but it involved a 49-year-old wife and mother from Wilton. She had been married for more than 20 years. She and her husband had 5 children. She homeschooled 4 of those children. She adopted 2 of them. She was rendered functionally a newborn after medical providers mismanaged her unruptured intracranial aneurysm, which resulted in multiple frontal lobe strokes. She was left partially paralyzed. She lost her memory and she lost her recognition of her husband and her children. She didn't know who they were. She now lives in a home for brain injured patients up in the North Country. Her family still lives in Wilton. Her husband of 20 years was left without his wife. Her 5 children were left without their mother. She, too, did not work outside of the home because she homeschooled her children, and she helped out in the family's landscaping business. In that case, the probate judge, because the husband was the guardian for his wife due to her brain injury, awarded almost half the malpractice settlement to the husband for the loss of his wife and familial relationship. Had his wife died, as opposed to being rendered permanently brain damaged and unable to recognize her family, the judge would have had to reduce that award by hundreds of thousands of dollars. The losses to these husbands and children are similar, and the recoveries were vastly, vastly different, and there's no rational basis that one husband's spousal relationship should be valued at $150,000, while another husband's spousal relationship has an unlimited value. There's no basis for that. That's completely arbitrary. The damages cap in the state is arbitrary. It's irrational. It certainly lies in the backwater of the modern stream, and it's lower than any other cap in the nation. It has not been addressed for 25 years. When it was enacted, it may have been reasonable to some because $50,000 might have paid for a child's education at the time in 1999. $50,000 isn't even going to pay for a year of a child's college in New Hampshire now. It's time to correct for this injustice with this bill. What you aren't going to hear, and what's not going to happen if this bill is enacted, you're going to hear testimony from a lot of people behind me who are going to tell you the sky will fall if these damages caps are eliminated. This is not the case. The sky has not fallen since the New Hampshire Supreme Court eliminated the caps on non-economic damages and personal injury and medical malpractice cases in 1980. It has not fallen since our Supreme Court eliminated the caps in wrongful death cases for people without dependents. Finally, it hasn't fallen in Maine over the last 25 years, and they have raised their consortium cap from $150,000 in 1995, which I suspect is where our $150,000 cap came from, to $1 million in 2023 with future increases for inflation. And the reasons that the sky is not going to fall in the state are the same ones that our court identified in Carson versus Muir. These claims are few and far between. Few cases are ever even going to reach the threshold of $250,000. Damage awards are a very small fraction of insurance premium costs. There are fewer wrongful death cases and general negligence cases. Businesses are already considering general negligence claims when they're making their insurance decisions. We don't have runaway juries in New Hampshire. New Hampshire's jury system works. I thank you for your time. I urge you to vote ought to pass for this bill and eliminate these caps because they are completely arbitrary and there's no reason for them in New Hampshire.
Thank you very much for your testimony, Ms. Haynes. Are there any questions? Senator Chandler?
Thank you, Madam Chair, and thank you, Attorney Haynes, for your testimony. At one point, you mentioned that this law as it exists now is New Hampshire telling survivors that, you know, this is all that your spouse or child or parent is worth. Do you have any concern that the inverse would be true if we remove the cap, that in an effort to determine what is in fact invaluable, we may go too high and have those runaway jurors that you mentioned?
I don't have that concern because jurors are very good at, we don't have those verdicts. And right now, a loss of consortium claim is unlimited in a general negligence case, and we've never had that problem. And if that ever happens, our judge would certainly reduce the verdict by remittitor. I don't foresee that happening at all. And jurors, based on their own experience, can place the value that they see fit based on the evidence on what the loss of someone's relationship should be worth.
Are there any further questions? Senator Gannon?
Thank you for taking my question. Just easy question. How few and far between are these? Is this like a handful of cases, half a dozen a year?
It's interesting. We tried to get that information from the circuit court and the superior court, and we weren't able to do it. Because they're wrongful death cases, the best place to get them is the circuit court, the probate court. But unfortunately, they just classify everything by estates. I can tell you in our office, they're a small fraction, probably 10% of the claims that we have are wrongful death claims.
Thank you.
Are there any further questions from the committee? Okay. Seeing none, thank you very much for your testimony.
Thank you, senators, and thank you for your time.
Okay. The chair will call Commissioner Betancourt. Good afternoon, Commissioner.
Afternoon, Senator. Good afternoon, members of the committee. My name is DJ Betancourt, and I have the pleasure of serving as the Commissioner of the New Hampshire Insurance Department. I am joined by my Deputy Commissioner, Keith Nyan. We are here this afternoon on behalf of our department to express our deep concerns with Senate Bill 462 and the potential unintended consequences passage of this legislation may have on the accessibility and affordability in our insurance markets. First, let me say that I appreciate some of the arguments that have been made by proponents in favor of this legislation. I have no doubt that those sentiments are sincerely held. I understand that these are very, very difficult cases, and this is not an area of law that I have spent much time in. My concerns, however, as you might expect, are for the insurance consumer, from the perspective of the insurance consumer. Very briefly, I want to address some of the challenges facing our insurance markets, not just here in New Hampshire, but nationwide, as a number of markets have begun to harden. During a hard or hardening market, the market is less competitive, and insurance underwriters adhere to stricter standards to better manage their risk exposure. The result is that while consumer demand remains at similar or greater levels for certain insurance products, it is more difficult for consumers to find those coverages. When this occurs, basic supply and demand principles take hold and premiums increase for consumers. Now, as a matter of fairness, litigation is not the major driver causing these hardening markets. The predominant drivers are the increasing number of weather-related catastrophic losses, persistently high levels of inflation, high interest rates, and nagging supply chain challenges. So given that, what does Senate Bill 462 have to do with the hardening market dynamic? Well, this law would represent a financial risk for an insurer that would be factored into their underwriting guidelines and rate filings at a time when carriers, as I mentioned, are tightening their risk exposure. This change would be an actuarially justified reason to raise premiums or, in extreme cases, result in a carrier choosing to cease writing a certain line of business. Nowhere is this a greater threat than for nonprofit organizations offering residential behavioral health services who are seeking professional and general liability coverages. This challenge has been one of the major focuses of mine as commissioner. These nonprofits are struggling immensely to find the coverages that I mentioned, and they are, when they do find it, struggling even more mightily to afford it. The result is not only a significant problem for those nonprofits and the individuals and families that they serve in our communities, but it's a problem for the state, because those organizations need those coverages, are required to have those coverages to contract with the state of New Hampshire to operationalize the outstanding services and funding that the legislature and governor have made available to strengthen New Hampshire's behavioral health care system over the past 8 years. As I said, my team and I are working aggressively to address that issue, but I fear that Senate Bill 462 will make that challenge more difficult. So, from an insurance perspective, those are my concerns and the reasons for them. And with that, Senator Carson, I would be happy to take the committee's questions.
Thank you very much for your testimony, Commissioner. Are there any questions for the Commissioner? Senator Whitley.
Thank you, Madam Chair, and thanks for taking my question. This is more of a general question. I'm also on Health and Human Services, and what are those? So we're talking about the possibility of premiums raising, which are a huge concern for families, huge concern. What are the mechanisms in place at the insurance department to make sure that any changes in what we do or any other changes aren't passed on to consumers? How do we keep that? How do we keep that balance? What do other states do? I'm sure we're not going to, this is not the only state that is contemplating getting rid of the cap. So what are the regulatory mechanisms to address those potential raises in premiums?
Sure. So we obviously have an actuarial team that will take a look at the underwriting factors that a company submits. They will look at the rates themselves to make sure that they're actuarially justified and that there's no discriminatory factors that are in play for either of those reviews. But here in New Hampshire, whenever a market is competitive, my team does not have the ability to disallow a rate increase just because they don't like it. We allow the power of the market to take hold at that point, which is to say we believe that if a company wants to have a large rate increase, well, their customers will look elsewhere, and they will go to a company that is offering a lower premium. So that was a long answer to your question, which is to say we have very few tools to disallow a company from taking into account the result of this legislation in their underwriting and rate filings.
Are there any further questions? Commissioner, I'm well aware of the difficulty that nonprofits are having with the insurance market, and I know that I have filed legislation and members of this committee have supported that to try to help these folks in today's current insurance atmosphere. But it's not very clear to me why, in this instance, we should really be concerned. My question to you is, are you concerned that if we remove the caps, that insurance companies are going to leave the state of New Hampshire?
Well, I cited the nonprofits as an example of one of the more extreme areas where I have concern. One of the areas where, as I said, we've worked very, very hard, and I don't want to see the work that you're discussing, Senator, and the work that we're doing as a department to be hindered by the passage of this legislation. But I think that this would have an impact on every market in some respects. Leaving the market, no, that would be pretty extreme, Senator. Not impossible, but that would be extreme. What you are more likely to see are rising premiums.
Okay. Thank you. Are there any further questions, Senator Gannon?
So in reading other people's testimony who are forthcoming, I saw a few places where they're talking about 11 to 15%. You probably would have a better idea if that's accurate. You know what's going on in other states. Is that what you'd anticipate the amount being?
Hard to say that it would be on par with that. I think one of the studies that I had seen was an actuarial study done in New York. I think that was somewhere in the range of 11 to 14%. There are a lot of other factors in the state of New York that make it less hospitable for carriers to do business there, but it will have an impact. It will certainly have an impact. Like I said, to that degree, I do not know for sure. I'm not an actuary, but it will have an impact, Senator. Yes.
Thank you.
Senator Abbas?
Thank you, Madam Chair. I'm not sure if you have the statistics, but wouldn't a lot of the auto policies, I'm kind of making a general statement, not even cover the $150,000, never mind you remove the cap? I mean, some insurance policies, I guess they have a max coverage that's below that amount. So can you provide any numbers on distinction?
Thank you, Senator. Really, what you're speaking to are the policy limits. And, depending upon the policy limits selected, excuse me, by the consumer, that cap may be exceeded. Or I guess more directly, the policy limits of the policy would be lower than that $150,000 cap, depending upon the product selected. We certainly encourage folks to purchase policies that limits reflect their lifestyle and their tolerance for claims. So in this aspect, I think the short answer is yes, some of the policies sold in the state, those policy caps are below the limits that we're speaking about today. And I would suggest with the removal of that limit, the pressure to purchase policies that do have higher caps would certainly increase, which would be one of the driving factors in rising costs.
Paul,
Raul?
do you have any information on what the average auto policy is for your typical consumer?
Senator, I do not have that information. We can certainly try to obtain that for you and follow up.
The one thing that I would add to that too, Senator, is to always be aware that New Hampshire continues to have the distinction of being the only state in the United States of America that does not mandate consumers have auto insurance policy. And there again, I think you've got to be mindful of the fact that if premiums do get to a point where it could get to a point where consumers start making decisions that I would say are bad decisions, but decisions where they think to themselves, well, I'm a really good driver. I don't drive very far. I think I'll just chance it and go without coverage. Again, not a decision that I in any way would endorse or encourage, quite the opposite. But that is something to be mindful, to be careful about the price points.
Senator Gammon?
Just a last quote. So would you recommend we go with something like Maine with $1 million cap? That way your actuaries would know, here's a fixed thing, it won't go beyond there. So that would help them keep the policy limits lower because they'd know it couldn't be a $5 or $7 million crazy number.
I think that's probably a better question for the carriers themselves. They're familiar with their particular underwriting guidelines, their particular formulas for setting premiums. They all have different risk profiles as well, so it's hard to say exactly how they might each react.
Thank you.
Just one last question, and thank you for that last answer. Because you talked about, that you're going to see a rise if we remove the caps. But are you saying that if we raise the cap to $1 million, that you're still going to see the rates go up anyway?
Well, my assumption would be that a raised cap versus no cap would make a difference. What I'm also saying, though, is I think that you're going to see premiums regardless go up.
Okay, thank you. Are there any further questions? Commissioner, thank you very much
Thank
for
you
your
all very much.
testimony. Okay, next we're going to call Dave Slosky. Do I have that correct? Yes. Good afternoon, Mr. Slosky. Okay, thank you. Thank you. Good afternoon.
Good afternoon. Thank you very much for taking a look at the summary that I sent out. My name is David Scott. I'm an attorney in Manchester. I've been practicing law in the state for a little over 30 years. Oops, that sounds better. Let me start again. My name is David Slosky. I'm an attorney in Manchester. I've been practicing law in this state for a bit over 30 years. I started out after law school working for Judge Devine in federal court. And then when Norman Stahl became a federal judge, he asked me to stick around for a year. So I helped him there. And since then, I've been in private practice. I'm in favor of this bill, as you've already heard from Attorney Haynes, and I don't want to restate some of the things that she said, but obviously for those of us who work with survivors, these are just incredibly compelling cases. I'm sure you all understand that. Unfortunately, my client was not able to join us today, but he asked me very sincerely to share his family story with you. And the story involves a family that lived just a few miles away from the St. Gobain plant down in Merrimack. And Stephen and his wife Shelley were married in 2001. They had three young children. As the world turns, Shelley worked for about 7 years for the Dana-Farber Cancer Center down in Boston. When her children were very young, she took a few years off and then went back to Dana-Farber, but at a time when they had an office in Londonderry. When she was 43, she was diagnosed with pancreatic cancer. And about a year and a half later, she passed. So I just wanted to talk briefly, and sort of the context is a conversation that I had with Stephen. And he's a very religious fellow, very active in his church. And I think couldn't believe that he was actually talking to a lawyer who might bring some kind of a lawsuit. And one of the questions that comes up is, well, what do you think the value of the case is? And so I wanted to just sort of present these top two pictures to you. So this is the top picture on the page one. That's Shelley and the three children. The youngest, Marquesa, was about 8 years old at the time. This photograph was taken down on Cape Cod roughly a year after Shelley was diagnosed with the cancer and started having her chemo and all that stuff. And the family went down to Cape Cod to do one of those reaffirmation of marriage ceremonies. This was about 2013, I believe. And the children, everybody knew that she didn't have long to live. 6 months later, she passed. The bottom picture on the first page, that's Steve and Shelley, and you can see Shelley has a cap on, and that's because she lost her hair through the chemo. What you can't see too well is that Stephen and the children also shaved their heads in support of their mother, his wife, and his hair starting to grow back. The second page is the same picture, but it sort of illustrates what these people lost, okay? And one of the most difficult things a jury has to do is to try to figure out, well, what's the dollar value of that loss? So going back to the conversation I had with Stephen, when he said, well, what do you think the value of the case is? I talked to him about the caps. And, it's pretty difficult to explain to a surviving spouse who's lost the love of his life and who tells compelling stories about putting his 8-year-old daughter to sleep at night when she's in tears every night, asking what happened to her mom, that, well, the legislature has determined that no more than $50,000 is the value of that loss to the children, and no more than $150,000 is the value of that loss to you. Now, a couple of things that I do want to touch on. One is, what happens when you get these cases into court? What does the jury know about the cap? Now, as you may know, in some states with caps like this, legislation specifically directs the judge to tell the jury about the cap. Our state does not have that. And as far as I can tell, the judges in New Hampshire don't allow arguments to the jury, or they don't allow the jury to know that. So it may be under the current statute that the jury thinks, well, let's give each of them $1 million. And then afterwards, the judge carves that down to $50,000 for the children and $150,000 for the spouse. This one-size-fits-all approach is somewhat shocking to me. And also, what is the great fear here? And I suppose one of the fears by the insurance industry and the defense is, well, we don't want these runaway verdicts. I can tell you that in New Hampshire, we don't see many runaway verdicts. I can think of, in my 30-plus years, I can think of 2 of them. And to some extent, addressing the concern of the insurance department, the first case I knew that had a very large verdict, both of these, by the way, were in federal court. First was against a very large pharmaceutical company, very likely no insurance involved in that. And the second one was against Walmart. The Patch family case that I have against the Saint-Gobain Performance Plastics. Saint-Gobain, as I saw on one list, they were, I think, the 257th largest corporation on the planet. No insurance there. So folks who are most likely to get these large verdicts before New Hampshire juries are probably going to go against the least sympathetic defendants around, those that are very well heeled and don't have any insurance. So these folks sort of get thrown under the bus with the rest of it. Otherwise, I just rely on the summary that I provided you. Be happy to answer any questions if there's anything I can help you with.
Thank you very much for your testimony, Mr. Slosky. Are there any questions from the committee? Senator Gannon.
Show me the money again. $1 million cap? Would you recommend a cap or would you recommend no cap?
I'd recommend no cap. As I think Attorney Haynes mentioned, there's something we call a motion for remitted, or every judge is told, as the opportunity. If a jury really goes wild, the judge says, we can reduce that. And as far as, one of the troubling things, I was chairman for about a decade of the largest bar association committee called the Committee on Cooperation with the Courts. And one of the things that we tried to do was to generate real data about jury verdicts in the state. We never got very far with that. Some court clerks in counties would keep a sort of a handwritten list of the jury verdicts. Today, of course, we do everything online, so I'd certainly encourage you to consider that kind of thing. Let's get some real numbers on these things. In federal court, I took a quick look to see over the last few years what's been happening there, and on the civil cases, personal injury type cases, I found one civil verdict for, I think, $180,000, and that was it. That doesn't mean that large settlements aren't happening, but those settlements are driven in part by statutes like this, where you look at the cap and say, well, the insurance companies and the defense attorneys say, well, what's the worst thing that can happen? And, that's part of the way that they value the case, and that's part of the reason why those settlements are lower than they are in other states.
Thank you.
Are there any further questions? Seeing none, thank you very much for your testimony this afternoon.
Thank you.
The chair will call Chris Appel. Good afternoon, Mr. Appel.
Good afternoon. Thank you, Madam Chair. My name is Chris Appel. I'm an attorney at the law firm of Shook, Hardy & Bacon in Washington, D.C. I'm testifying in opposition to SB 462 on behalf of the American Tort Reform Association, which is a broad-based coalition of businesses, municipalities, associations, and professional firms with an interest in promoting greater balance and predictability in civil litigation. My goal here is to provide more of a national perspective on the topics of wrongful death damages and loss of consortium claims to help explain the importance of limits on these awards. At first blush, you might look at New Hampshire's $150,000 cap on loss of spousal consortium claims and $50,000 cap on child and parental consortium claims and think, gee, these limits seem kind of low. Well, there are a few key points to keep in mind that provide context to these limits and show how they keep New Hampshire wrongful death recoveries in the mainstream. First, although most states allow some manner of loss of consortium arising from a wrongful death, it is important to keep in mind that some states do not. In other words, there is no recovery for loss of consortium, whether it be spousal consortium for the death of a partner, child consortium for the death of a parent, or parental consortium for the death of a child. Some states also only recognize spousal consortium claims and not consortium claims arising from the parent-child relationship. In the context of wrongful death, though, New Hampshire recognizes all three types of consortium claims. Second, of the states that allow recovery for loss of consortium in wrongful death, around a dozen limit that recovery only to pecuniary or purely economic harm, such as the lost value of a decedent's labor or other services, as opposed to emotional loss. New Hampshire, in comparison, allows more subjective recovery of emotional loss for comfort, society, affection, guidance, and companionship. It does so with the trade-off of capping those damages. Third, of the subset of states that allow broader recovery for emotional loss that includes loss of consortium, approximately 10 limit or impose statutory limits on non-economic damages in wrongful death cases generally, while 17 impose specific limits on non-economic damages in wrongful death cases arising from alleged medical negligence. And there is some overlap with some states having general caps and medical malpractice caps, but overall, about half of states have some non-economic damages cap. These caps are set at higher amounts than New Hampshire's because in almost all instances, they limit the total non-economic damages that can be awarded in a case, not just damages for loss of consortium. In that regard, it is important to keep in mind that for each consortium claim, spousal, child, and parent are derivative claims in the context of a wrongful death. That is, they exist in addition to what is recovered under New Hampshire's wrongful death statute in an action brought by the administrator of a decedent's estate. An estate is entitled to bring a wrongful death action to recover damages that compensate for things like the mental and physical pain suffered by the decedent, which is non-economic in nature, the decedent's lost earning capacity, the decedent's probable duration of life but for the injury, and reasonable expenses such as medical bills or funeral expenses incurred by the estate on account of the wrongful death. New Hampshire is also one of only a handful of states, I believe just 6, that permits recovery of a decedent's loss of the enjoyment of life, also known as hedonic damages. And for what it's worth, even the very progressive-minded American Law Institute does not endorse that scope of recovery for a wrongful death. And perhaps most importantly, there are no limits on any of these types of damages. The only limits are on the derivative loss of consortium claims. So when you step back and look at the broader picture of the broader legal landscape of wrongful death recoveries and consortium, New Hampshire's allowance of a capped emotional harm recovery for consortium claims is in the mainstream. This is why you don't see some of the issues you see in states like Florida or California, where unjustifiable awards that are frankly untethered to reality are an all too common occurrence. Those jurisdictions do not place meaningful controls on subjective, non-economic components of wrongful death awards. I submit if you eliminate the caps on economic or emotional harm damages for loss of consortium, then there is really nothing to prevent so-called nuclear verdicts in every wrongful death case, especially when you combine that uncapped amount with uncapped hedonic damages. And finally, and relatedly, there does not appear to be any clear evidence that New Hampshire wrongful death claimants are not getting appropriate awards. I couldn't help but notice that some of the anecdotal examples provided listed the application of the caps, but didn't report on the total amounts that were actually awarded in those cases or obtained through settlement. A simple Google search turns up plenty of examples of plaintiffs' law firms boasting about large awards they have obtained. And so for all of these reasons, I respectfully urge the committee to reject this bill, and I'd be pleased to answer any questions.
Thank you very much for your testimony, Mr. Appel, I'm sorry.
It's okay.
Are there any questions from the committee? Senator Abbas.
Thank you, Madam Chair. So just to clarify your testimony, the cap on that relates to wrongful death only applies to emotional harm?
It only applies to loss of consortium, which includes emotional harm in the spousal, parent, and child relationships. But You can get emotional harm damages, as I mentioned, what are called hedonic damages, or loss of the decedent's enjoyment of life, which, I don't know, I mean, a jury has to be really sharp to be able to separate the two, but loss of enjoyment of life versus loss of society for the family members, it's hard not to see some overlap in that. But the hedonic damages for the decedent's loss of enjoyment of life are uncapped in New Hampshire.
Okay, follow up?
Thank you, Madam Chair. So I understand you're not in support of removing the cap, but if those caps are increased to any number, is there any recommendation you would have for what that number should be?
I mean, unfortunately, all caps are arbitrary in the sense that you're basically, as a legislature, picking a number and saying this is where we think is reasonable. So do I have a specific number? No, I would not.
Follow up?
Thank you, Madam Chair. I guess my concern is, it's one thing to remove the cap, but the cap right now hasn't been adjusted for about 25 years. So I guess my concern is when they first implemented this cap of $150,000 and $50,000, there's a different monetary value, shall we say.
Yeah, I'm sorry.
There's a different value of what that was 20 years ago. So I guess my concern is if we were to increase it.
Yeah, I mean, there's certainly the argument to be made that the purchasing the dollar just from inflation alone has changed in value. But I would submit that there are numerous states that have caps, a strict cap that they've had for many decades. It's as I mentioned in my oral testimony, it's not that unusual. Actually, about half the states have some non-economic damages cap, and within that group, most are strict caps.
Thank you.
Okay, are there any further questions? Senator Chandler?
Thank you very much. And I'm sorry to ask, but when you were introducing yourself, this is my fault, I missed it, you said something about your organization promotes a greater balance, and I didn't understand, I didn't hear. Greater balance?
Greater balance and predictability in civil litigation. So like a cap on damages would provide greater predictability in civil litigation.
Are there any further questions? Seeing none, thank you very much for your testimony.
Thank you so much.
The chair will call Jared O'Connor. Good afternoon, Mr. O'Connor.
Good afternoon, Madam Chairman. So my name is Jared O'Connor. I'm here with the New Hampshire Association for Justice. And I'm also here on behalf of myself. As an attorney here in New Hampshire, I've been a workers' compensation lawyer for about 20 years, currently with the firm of Shaheen and Gordon. I'm here in support, and I'm here to testify on a fairly limited issue, fairly discreet. It's my understanding that there's an objection to this bill on the grounds that it will raise the rates for workers' compensation carriers, and that's really what I'm here to speak to. That's all I know as part of my practice. And so, having not heard the details of the objection, I have to admit I find it somewhat baffling. I can't imagine how this could possibly affect workers' compensation carriers, because the way that workers' compensation works, and has worked for over a century, is that injured workers and their families are prohibited from suing employers if there's an injury due to whether it's the negligence of the employer or a straight no-fault injury on the job. So the way it works is when there's an injury, and in this case, if we're talking about death, if there's a death on the job, what the worker gets in the family is a weekly disability benefit equivalent to what the worker would have gotten had they been alive. And that's what goes to the family and the dependents for a limited period of time as defined in our workers' compensation statute. That's what they get. That's what they get under existing law. And this removal of the cap doesn't change that. It doesn't change the fact that the injured worker, the estate, and the dependents cannot bring suit against the employer. That's at 281A8. And you can look that up. It's Roman 2. And it, as I say, is a flat prohibition on bringing suit. So regardless of what family members may seek as a loss of consortium claim against some third party, whatever the amount is that's awarded to them is not going to change the benefit that they get from the workers' comp carrier. So it can neither increase nor decrease the amount that's payable. So really, that's all I'm here to say, is that I can't imagine any effect on the limited universe of workers' compensation claims. Are there any questions about that?
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you very much for your time this afternoon.
Thank you.
The chair will call Dave Jouvet.
Thank you, Madam Chair, members of the committee. For the record, my name is Dave Jouvet. I'm a Senior Vice President with the Business and Industry Association. We serve as New Hampshire Statewide Chamber of Commerce. We have approximately 400 employer members employing over 100,000 Granite Staters. We're here in opposition to this bill. I'll keep my testimony relatively short because you've already heard many reasons why this would be of concern to employers, and both in terms of increased insurance cost and the potential that insurance companies may choose to leave the state. I just want to make one comment. The sponsor, the chair, mentioned that this cap hasn't been increased since its inception. She is correct, but this bill doesn't increase the cap, it eliminates it. And Senator Abbas, you were asking what a reasonable increase could be, I think, if I could paraphrase. And I don't have response for that, but I did quickly look up using a CPI inflation calculator. And if you plugged in $150,000 in 1997, that would be worth approximately $290,000 today. I'm not suggesting that's what we would support. I'm just suggesting that's what the inflation rate is.
Thank you very much for your testimony, Mr. Jouet. Are there questions from the committee? Seeing none, thank you very much. The chair will call Chris Seifert. Good afternoon, Mr. Seifert.
Good afternoon, Madam Chair and members of the committee. My name is Christopher Seifert. I practice in Franklin, New Hampshire. Been practicing law since 1984, so a couple of years. I want to point out three quick things and then a brief statement. One, the insurance commissioner testified that somehow if we raise caps, that will have an impact on nonprofits. But we all know that we already have a cap on damages against nonprofits under 50817, and it's $250,000 one individual and $1 million for everything. So I fail to see how that argument makes sense here before you this afternoon, because they already have the benefit of caps. Two, Senate Bill 423, we heard some testimony, I think, last week. I'm not sure how many of you heard that, but that testimony included that New Hampshire is the 7th most profitable state in the nation for insurance companies per premium dollars collected. So the insurance industry makes more money here than in most other states. So them arguing that somehow the lights are going to go off and the insurance is going to pull out of the state and everything's going to go dark doesn't make sense when you look at that profitability. And third, the commissioner said that New Hampshire is the only one that doesn't require car insurance, and that's wrong, because in Virginia, you can pay a $500 fee and drive around without car insurance. So really, there's two states. So those are the corrections I wanted to make. And then lastly, I guess my remarks are, if we're valuing life as opposed to valuing, say, the loss of a body part. So if you had your choice and someone were to say, you can lose your wife or a child, or we can take your leg off or take your arm off. How many of you would say, take my arm or leg, don't take my child? We value life that smallly that we can't value it more than the loss of a limb, because there's no limit on a loss of a limb. If you lose a leg or an arm, the jury can award any amount of damages. But if someone's going to take your child away and your spouse away, we have these arbitrary limits. It just doesn't make sense. And lastly, as some of the speakers have said, New Hampshire has a long tradition of we have the sacred right to a jury trial, Part 1, Article 20 of our state constitution. That's in our constitution. Do we trust our constitution and our sacred right and our juries to get it right in this state? And if we do, we leave this to the discretion of those jurors and not put arbitrary limits on the loss of a loved one. Thank you.
Thank you very much for your testimony. Are there any questions from the committee? Nope. Seeing none, thank you very much.
Thank you.
The chair will call Kirsten Schultz.
Good afternoon, Madam Chair and committee members. My name is Kirsten Schultz. I'm an attorney with Nixon Peabody in the Manchester office here in New Hampshire. And I am here representing State Farm, one of the leading writers of auto and home insurance in the United States and here in New Hampshire. And we are here to oppose SB 462. And the reasons for our opposition largely track what my fellow witnesses here have raised in terms of concerns in opposition to this bill. I've also submitted the written testimony to the record, and I'll just briefly spend a moment summarizing its main points. I think we can all agree on the starting point here, which is that every human life is valuable, and current New Hampshire law recognizes that fundamental truth. In a wrongful death action, New Hampshire law allows a decedent's estate to recover significant categories of damages, both economic and non-economic damages, which are not capped. These damages flow through the estate to compensate the decedent's heirs, specifically including a spouse, a child, a father, a mother, or any relative dependent on the decedent, without any limitation, again, on the amount of those awards. And we do entrust our excellent jurors here in New Hampshire, our excellent, smart, perceptive, hardworking, engaged jurors here in New Hampshire to assess those damages and what attributes to consider when an estate seeks compensation for its losses resulting from a decedent's death. Similarly, subject to these reasonable caps, New Hampshire law rightfully allows damages for wrongful death claims related to the loss of a relationship with a loved one caused by untimely death due to negligence or carelessness or other misconduct. And the current law here in New Hampshire strikes the right balance on this very tough subject. As it stands, it permits meaningful compensation for family members' emotional damages, including the loss of comfort, society, companionship, guidance, affection. The law also provides certainty and stability. And we think that removing the caps risks these unintended consequences that others have testified about today, including the possibility for increased insurance premiums, potentially extraordinary financial liability for the vast majority of consumers who purchase insurance, and for other businesses, healthcare facilities, healthcare providers, and limiting the potential for insurance availability challenges could result from removing those caps outright. So for those reasons, we oppose the bill, and I'm happy to address any questions if I'm able.
Thank you very much for your testimony this afternoon. Are there any questions? Senator Abbas.
Thank you, Madam Chair. And same question as the previous witnesses. I know there's some opposition to removing the cap in its entirety, but perhaps something to at least take into consideration inflation. Is there any opinion on that?
Did you say taking into account inflation?
Yes.
Yeah, so State Farm has not assessed the possibility of assigning an actual number to a potential increase, but I think that any cap would be preferable to an outright removal of the caps. But it's something that we have not yet fully assessed.
Thank you.
Are there any further questions? Thank you very much for your testimony.
Thank you.
Okay, the chair will call. Good afternoon, Mr. Russo.
Good afternoon, Madam Chair. Thank you, members of the committee. My name is George Roussos. I appear before you on behalf of two clients, the New Hampshire Association of Domestic Insurance Companies and the American Property Casualty Insurance Association. These clients' members are insurance companies that write most of the liability insurance in New Hampshire. And we share the concerns that have been expressed about the consequences of eliminating the cap on consortium and parent-child awards. There's been discussion about what current law permits with respect to wrongful death claims. And I think it might help clarify it if you would look at the bill itself, Roman numeral 1, which refers to the estate claims and wrongful death actions. That's been law for a long time. And as it states expressly, the awards can include mental and physical pain suffered by the deceased, reasonable expenses occasioned by the estate by the injury, probable duration of life but for the injury, capacity to earn money during the deceased's party's probable working life, all that may be considered currently. Those are claims of the estate that, as has been mentioned, flow down to the beneficiaries of the estate, ordinarily the spouse and the decedent's children. So there are no caps on those awards, and those awards can be substantial. In 1997, the legislature added Roman II, which provides the consortium claims, which did not exist in wrongful death cases until then. And in 1998, the legislature added Roman III, providing recoveries to minor children and to parents given the loss of a child, capped at $50,000. Those bills were controversial when they were enacted, but they were enacted as a compromise, and they were enacted recognizing the potential for otherwise uncontrolled subjective awards of damages, given what we all agree with is a profound loss that we're talking about now, as almost unimaginable, the loss of a child or a child's loss of a parent. And it's precisely for that reason that damages are limited, because the potential with the emotions of that are attendant on these losses, and you've heard some of the anecdotes that have been told by the plaintiff's lawyers, that the capacity exists for extremely high jury awards. And you may see some of those awards, but most of them, as you know, are the results of settlement of cases based on what a jury might do. It's been mentioned that it would be nice to get some real numbers on the actual cases, and I agree with that. I think that before you go ahead, it would be very good to make that determination. It would also be very nice to ascertain the costs that this bill would result in, rather than people just guessing about what they might be. And when it comes to costs, I think it might be helpful to look at legislation in other states. The plaintiff lawyers have brought these claims nationally, this type of legislation, including in the state of New York. And New York actually passed legislation similar to what this bill would provide. And in connection with that case, with that bill, Milliman, the actuarial firm, did an analysis of the effect on costs, and they were significant. Something like over 11% increase in losses and 15%, 15.5% in additional losses paid by self-insureds. This is not just med-mal cases, although that's a primary example, but Milliman also looked at general liability claims which businesses buy, and at personal and commercial automobile claims. And if I recall correctly from that study, in terms of the amount of such wrongful death claims, I think it was, again, I need to check that study. I'd be happy to share it with you, the New York Milliman study.
Okay.
But it was a high number of wrongful death claims that they looked at. And I want to say it's something like 6%, although, again, need to double check that. And I will send you that Milliman study. But it's based on that, a coalition in New York of businesses, chambers of commerce, medical providers, hospitals, and insurance companies joined in opposition. And Governor Hochul, just in December of this year, vetoed that legislation, saying that, this is her veto message, the bill would fundamentally alter the legal framework for wrongful death claims in New York by expanding the types of damages that may be recovered and expanding the class of persons who may recover. Legitimate concerns have been raised that the bill would likely lead to increased insurance premiums for the vast majority of consumers, as well as risk the financial well-being of our healthcare facilities, most notably public hospitals that serve disadvantaged communities. So you can look to that study as indicative of cost. I have to mention that it's hard to talk apples to apples because there's so many differences among what state laws provide. And New York currently has no rights for consortium claims or parent-child claims. So the effect, I would guess, would be less than what was described in New York, but still, we believe, a very significant number. A few statements were made that I'd like to address very briefly. Workers' comp was mentioned, and to my knowledge, this bill has nothing to do with workers' compensation. It was mentioned that there's a cap on damages for nonprofits of $250,000, RSA 50817, but that statute only applies to volunteers. So it's really has nothing to do with this case either. So there's been, Senator Abbas isn't here, but he's asked the question about how amenable would folks be to an increase? And I've talked to some of the businesses here and some who may have presented written testimony, others who share concerns that aren't here. And I think that there's a general sense that something might be appropriate. And we'd be happy to work with whoever to talk about that. I think that my clients would be a little more conservative than some folks might be, but we're always open to discussion. I'd say we're more conservative because we didn't agree to the caps currently in existence for spousal claims or parent-child claims in the first place. And so from our perspective, building upon a law that we don't agree with is not the best way to go. But having said that, we're always willing to talk, and if that's the will of the committee, we'd like to participate in those discussions.
Thank you very much for your testimony, Mr. Russos. Are there any questions from the committee? Seeing none, thank you for your time.
Thank you.
The chair will call Kimberly Kirkland. Good afternoon.
Good afternoon. Thank you for hearing from me. Again, my name is Kimberly Kirkland, and I am a lawyer practicing here in Concord, and I'm also the current president of the New Hampshire Association for Justice. I don't want to rehash what's been said, so I hope what I can do, I think, is summarize the position of those of us who support removal of the caps. From what I've heard this afternoon, there is no dispute that these caps are arbitrary, and there's no dispute that losses of family members of people who die as a result of negligence may go uncompensated in the presence of these caps. So if we take a specific example of an auto accident where there's a drunk driver and we have a spouse killed by a drunk driver, a family seeks to recover for that loss, they can recover for any lost wages or future income, and they can recover for that person's loss of enjoyment of life. If the death was instantaneous, there will be no recovery for any conscious pain and suffering. If that spouse or parent was somebody who didn't work, was a stay-at-home spouse or family member, the only recovery will be for the loss of enjoyment of life. So the contention that's been put forward that the spouse and children recover adequately through the amount that will get awarded to the estate under the wrongful death statute is just inaccurate, because it depends on whether that person works outside the home or not. And in my experience, frankly, with respect to settlements and insurance companies, will depend on the socioeconomic class of the person who died. In cases where we represent people who've been injured as a result of malpractice, or somebody who's been injured as a result of a drunk driving accident, insurance adjusters tend to value cases more highly if you've got a middle class or upper middle class plaintiff or family than they do if it's a working class person. And so the value of the person's life, according to how much they could earn over the course of their lifetime, or what their enjoyment of life will be, is not a fair compensation to the children and spouse for what they've lost in terms of the relationship. So there's no question that a family member of somebody who's killed as a result of that drunk driver is not going to be able to recover for the loss of the relationship with their spouse or their parent in the same way that somebody who is injured in that accident's family can recover. And there's no rational basis for that distinction. It's just not fair. It's not fair that if the drunk driver was lucky enough to kill their victim, their insurance company, or they themselves, if they didn't have insurance, don't have to pay for the damages, the loss suffered by the family of the person they killed. So in a circumstance where we have caps that are arbitrary and are unfair as compared to other people who suffer similar types of losses, it seems to me that the burden is on those who are arguing for the caps to demonstrate that there is evidence that the economic benefit of preserving these caps is essential. So essentially what they're saying is, yes, these people may have lost something. The wife, husband, children have lost the relationship with their family member, but the burden shouldn't be on the negligent person or their insurance company to bear that loss. They bear that loss on their own if the spouse or family member was killed. And I don't think you've heard anything here but speculation about financial consequences of eliminating these caps. So there was testimony from Mr. Russos about the New York statute, or it was a proposed statute that he, as he mentioned, Governor Hochul vetoed. I believe he's referring to the Grieving Families Act. I'm not an expert, but it's my understanding that that legislation, that proposed legislation, vastly expanded the categories of people who could recover when somebody died as a result of someone else's negligence. The removal of caps here will not do this. It doesn't change who can recover. It's spouse, children, dependents. Also, I believe that statute or proposed legislation would have changed the statute of limitations for wrongful death claims. And so it would have expanded the category of people who could file claims by virtue of expanding the time you could file claims. And if I understand correctly what happened in New York, that legislation never passed. So the study, I'm not familiar with the study that Mr. Russos referred to, but that study has to be speculation about what would have happened had that legislation passed. And again, I think the burden is on those opposing this legislation to demonstrate that the things that Commissioner Betancourt talked about, a hardening of the insurance market, an increase in premiums, and a drop in the number of people providing, or insurance companies providing insurance in New Hampshire is going to be the result of this. I don't think we have that evidence. In Illinois, in 2010, there was a statute passed to repeal wrongful death damage caps. And in the following 4 years, premiums dropped 16%. The losses, meaning the amounts paid out by insurance companies, dropped 21%. And the number of insurers in the market increased 17%. You heard the insurance commissioner say that litigation, what actually happens in terms of the experience of insurers in insuring businesses, individuals, healthcare providers, the litigation filed really does not affect premiums. That's not what affects premiums. Commissioner Betancourt said that. It's my understanding, I'm not an insurance expert, but it's my understanding that probably the largest factor affecting premiums is the stock market. And if the stock market is doing well, insurance companies are making money, they don't tend to raise premiums. If the stock market is doing badly, the insurance companies are looking to increase their profits, and they do that by increasing premiums. So I think in looking for evidence of what will happen here if we remove these damage caps, you've got to be looking at real experience of other states where damage caps have been removed, and what is the relationship of litigation to premiums versus how the stock market is faring to premiums. That's all I have. I'd be happy to answer questions if I can.
Thank you very much for your testimony. Are there questions from the committee? Seeing none, thank you.
Thank you.
The chair will call Ben Bradley.
Good afternoon,
Good
Madam
afternoon.
Chair. For the record, my name is Ben Bradley. I'm the Vice President of State Government Relations for the New Hampshire Hospital Association. We represent all the state's acute care hospitals as well as all specialty hospitals in New Hampshire. The Hospital Association and our members are opposed to SB 462. While hospitals in New Hampshire remain committed to providing quality health care to their patients, they continue to face significant operational challenges to meet the needs of their communities. If SB 462 became law, hospitals could be faced with an omnipresent cloud of potential limitless liability, influencing where providers decide to practice, their chosen specialty, and what procedures they would be comfortable performing. New Hampshire has maintained a cap on damages in wrongful death cases to ensure the stability of medical liability insurance costs and to provide an environment under which hospitals can be insured and support a strong workforce. In data reported from 2020 alone, New Hampshire hospitals had 1,016,979 inpatient admissions, 5.6 million outpatient visits, 637,000 emergency department visits, and supported the delivery of 12,714 babies. Hospitals and health systems play a vital role in New Hampshire's economy as community anchors, supporting local business and community development across the state with over 45,000 people employed by our members. We're also concerned that without caps on damages, we could see an increase in meritless lawsuits and exasperated healthcare costs. Lifting the cap could increase awards for unpredictable, non-monetary losses, which we've heard from the Department of Insurance and carriers themselves, increases the cost of liability insurance. Some providers, like obstetricians and surgeons, already routinely pay significant costs per year for liability insurance. I also just wanted to note my appreciation for Mr. Russo's indication about nonprofits. We have several nonprofit hospitals in New Hampshire, and as he noted, that limit applies to volunteers. Of course, we employ those our member hospitals that are nonprofits employ the providers and care teams that take care of patients. Thank you.
Okay, thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you. The chair will call John Wolkowski. Good afternoon.
Come before you in support of Senate Bill 462.
Wolkowski, I'm a practicing attorney as a partner at Bacchus, Meyer and Branch in Manchester, New Hampshire. I've been practicing for 37 years. I'm going to make this short and sweet. I don't need to reiterate the testimony that the committee has received on behalf of my esteemed colleagues here today. What I'm hearing, and I have no prepared notes, what I'm hearing from the opposition is they're looking for stability of insurance premiums. They're only talking about possibilities of runaway awards. And I would echo Attorney Kirkland's specific comments that they bear the burden of showing some economic harm if this bill passes. And I would submit, based on what I've heard here today, they don't have the appropriate level of sufficient evidence to warrant that proposition. I've been practicing primarily representing individuals, and the devastating losses that have occurred when you lose a spouse through the negligence of somebody else is very hard to put a price tag on. We trust our jury system, and as indicated beforehand, if there's some weird and wacky jury award or a verdict, the appropriate remedy is to file a motion with the trial court to make the appropriate adjustments. Our Constitution provides full, fair, and adequate compensation for victims who have sustained injuries, and in this particular case, to award a reasonable, fair amount of those people who have lost a spouse or a child. I would urge passage of this legislation. And that's all I have, unless there are any questions.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you very
Thank
much.
you very much.
And the chair will call the last speaker, Marissa Chase. Okay. Are there any other members of the public that would like to speak to Senate Bill 462? Okay, seeing none, we'll end the public hearing. Did he fool you and go around the other side? Thank you. Oh, my goodness. Okay, we got a lot of people here. Okay, well, no, not really. Oh no, it's 2, 6, 24. Okay, and then here we got 1, 2, 3, 4, 5, 6, 7, 8. So there's 8 speakers. That's not too bad. Let's see. I'll do this for you. Oh, sorry, I use colored pens. It makes it. Oh no, she's not speaking. Okay, here, 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 here. So we're gonna take a break after this, after this. Okay. So because we should continue on.
Yeah.
Okay. Okay. Oh, this is here.
Oh, my goodness.
Big Mark. Senate Judiciary is back in session. We're going to hear SB 422. Senator Carson's been introduced to us. Welcome, Senator Carson.
Good afternoon again, Mr. Chairman and honorable members of Senate Judiciary. For the record, my name is Sharon Carson, and I have the pleasure of representing Senate District 14, comprising the towns of Auburn, Londonderry, and Hudson. And I have this afternoon for your consideration Senate Bill 422, which seeks to change several references and modifying language in parentage and birth records. So, Mr. Chairman, what does Senate Bill 422 actually do? This bill updates New Hampshire law so that the acknowledgements of parentage, or AOPs, also called voluntary, again, acknowledgement of parentage, or VAPS, can be signed for children born through assisted reproduction and gamete donation. I want to make sure I get that correct. This means that more children can have their parentage established close to birth and through a voluntary process rather than requiring their parents to go to court to file litigation. It is important for these children and families to have equal access to the security of legal parentage. And since VAPS are the equivalent of court decrees, this means that New Hampshire children will also be protected wherever they travel. This bill also aligns New Hampshire VAP provisions to have language inclusive of all families as already exists in other New Hampshire statutory provisions. Senate Bill 422 has been developed with the consultation of New Hampshire Vital Records and New Hampshire Child Support. So what does this bill not do? It does not change who can be a parent in New Hampshire. It simply lets current parents protect their children through VAPS. Why is this important for New Hampshire children? It is a key public policy to secure the parentage of children efficiently and soon after birth. Parentage is the source of all rights and responsibilities for children, like health insurance, financial support, and medical decision-making. By allowing children born through assisted reproduction equal access to parentage through a VAP form, New Hampshire ensures these children are protected more quickly and without the expense and delay of filing litigation in court. Why is this important for efficiency? Right now, children who are born through assisted reproduction can only be secured through a court or a litigation process, whereas other children can be secure through the acknowledgement of parentage. With this bill, there should be fewer cases going to court because parents of children born through assisted reproduction can use an AOP form just like any other New Hampshire parent. Who supports this bill? Well, Mr. Chairman, this is a common sense bill that enjoys a lot of support. You have the New Hampshire Hospital Association and Dartmouth Hospital. Hospitals play a key role in the AOP process because federal law requires them to administer this form, AOP form. It's important for hospitals to be able to participate in a process that supports more families. Vital records, again, has been important in formulating this bill. Child Support Division, they have been involved in this as well. You also have local practitioners and families, the new Academy of Adoption and Assisted Reproduction Attorneys, Resolve New England, and the LGBTQ community, GLAAD, Family Equity, and an organization called Collage. So exactly, Mr. Chairman, what is the acknowledgement of parentage? It is a short, simple form when signed voluntarily by two parents, and it establishes the child's legal parentage. It can be signed at birth, in a hospital, or afterwards. It can be rescinded for any reason within 60 days. After that, parentage is established unless there is evidence of fraud, duress, or material mistake of fact. The AOP is the equivalent of a court decree in parentage and must be respected by other states. Most non-marital children have their parentage established through an AOP. It establishes parentage quickly and securely, and it saves the resources of the courts because it means that parents can establish parentage by agreement and not through contested litigation. Current law in New Hampshire allows a birth mother and alleged genetic father to establish parentage by this form. Why does the federal government require this? Well, since the mid-1990s, federal law has required each state to have a simple civil process to establish parentage, which is, again, the voluntary acknowledgement of parental process. The goal of this federal program is to ensure that parents are secured to their children for the purpose of support and health insurance, so parents are supporting the children rather than the government. Every state has this form. A majority of children born to unmarried mothers and fathers have their parentage secured by this VAP form. So what is the current trend in the AOP, and which, again, remember, is establishment of parentage? The Uniform Parentage Act was updated to reflect advances in science, best practices, and the diversity of families. This occurred in 2017. In that version, the Uniform Law Commission recommended to states to expand access to VAP forms so that children born through assisted reproduction can be secured through this program. This voluntary administrative route is a key procedural route to parentage that should be open to more children. This Article 3 of the UAP 2017 was written by the lead consultant to the Federal Office of Child Support Services and expanded access to voluntary acknowledgments of parentage is approved by that federal office. And finally, Mr. Chairman, since that time, 11 states have moved to expand access to this process for the children and their families. If you'd like, I can read the 11 states, but just be aware that it's my understanding that this legislation has been filed in more states in order to get uniformity across the country. So with that, Mr. Chairman, I will conclude my testimony, and there are folks here who worked very, very hard on this legislation who could answer your questions much better than I can.
Thank
So,
you, Senator
thank you,
Carson.
Mr.
Seeing
Chairman.
no questions, thank you. At least I'm going to try this Dakowski. I've seen it before, I should remember. Well, say it again for me.
It's
Your last
Lisa Dekatowski.
Dakowski.
Yes.
Thank you.
Thank you. Thank you, Mr. Chairman and Madam Chair, and members of the Senate Judiciary Committee. My name is Lisa Dekatowski, and I am here on behalf of the New Hampshire Department of Health and Human Services, the Bureau of Child Support Services. And thank you for giving me the opportunity to speak about Senate Bill 422. The New Hampshire Department of Health and Human Services, through our Bureau of Child Support, administers naturally the child support program as it was established through the title Roman numeral 4D of the Social Security Act of 1975. And as Senator Carson had already stated, that we have been engaged in conversations with the group that has helped to put this forth. And federal law, in fact, does require that the states have voluntary acknowledgments of parentage. And one of the child support's core program functions includes establishing paternity specifically. And of course, naturally, parentage establishment is a necessary first step in the child support enforcement process in cases where children are born out of wedlock. The changes that are proposed in this bill, the department is certainly supportive of the underlying movements here. Naturally, the main purpose of our child support program is to ensure that assistance in obtaining support is available to all children, and for whom that assistance is requested upon us to assist them. The changes that are proposed in this bill align with, as already mentioned, what we know our federal partners are in fact recommending for language changes in federal regulations, specifically changes to references from paternity to parentage. And this bill will not have any contrary effect to our ability to continue to operate the core functions of our Title 4D program here in the state of New Hampshire. It will require the department to make some changes to our existing affidavit of paternity form, and certainly training materials that we will need to work with collaboratively with our Division of Vital Records, to which we think these proposed language changes within the department, we feel that we can certainly absorb these within our existing resources. So just wanted to be able to acknowledge the work, and also want to be able to say that the department is appreciative of the effective date recommended in the bill to allow for an appropriate amount of time for us to potentially make any necessary changes. And I would be more than happy to answer any questions.
Okay, thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none, thank you. The chair will call Ben Bradley. Good afternoon again.
Thank you, Madam Chair. For the record, my name is Ben Bradley. I'm the Vice President of State Government Relations for the New Hampshire Hospital Association, representing all of the state's acute care hospitals and specialty hospitals, including our 15 birthing hospitals. I'm here to testify in favor of SB 422. We support updating the language in the birth worksheet and birth records to make the forms more inclusive by using terms such as birth parent and non-birth parent. Updating the language in these documents will ensure all patients and their families are able to complete the forms without confusion. Further, the proposed changes are inclusive and will help healthcare professionals provide compassionate care. We support efforts to ensure that all patients and their families feel comfortable when seeking medical care and want to reiterate our support for this bill. Thank you.
Thank you very much for your testimony. Are there any questions for the witness? It's seeing none. Thank you. The chair will call Beth Scare. Good afternoon.
Hi, I'm Beth Scare, grandmother from Nashua, and I'm here to testify in opposition to SB 422. Removing the words mother and father from birth records denies our very humanity. Every child has a mother and father. This change would create a fiction that a child was created by two people that may have had nothing to do with his or her conception. This bill also furthers the lie that biological sex doesn't matter when we know that only women can birth children and only men can father children. And every child deserves a mother and a father. Creating a child in order to purposely raise that child without a mother or without a father is damaging to a child's well-being. Everyone knows this instinctively. Can you imagine a 10-year-old asking her two male parents, "Where is my mother?" and finding out she was created through surrogacy for money? The heartbreak would never be healed. I know what it's like to grow up from a young age without a father in the home. It broke my heart over and over that he was separated from us, and I could never have my mother and father together in the same household again. We should strive to prevent situations where a child is separated from a birth mother or birth father and not give them a legitimacy. This bill puts the rights of adults ahead of children, which is completely backwards. Vote ITL on SB 422 to protect children. Thank you.
Thank you very much for your testimony this afternoon. Are there any questions from the committee? Seeing none, thank you very much. Ma'am, do you have written testimony you would like to? Thank you. Okay, great, thank you. Okay, the chair will call Christine Hanesco. Good afternoon.
Good afternoon, Madam Chair. It's so dry in here.
It is.
If I may, Senator Perkins Polka could not be here today, and I would like to read her testimony first.
Okay. Is it very long?
No.
Okay.
And I promise mine will be even shorter.
Okay.
Madam Chair, members of the committee, thank you for the opportunity to provide this testimony on Senate Bill 422, an act changing several references and modifying language in parentage and birth records. I regret that I am unable to attend this hearing in person. Parenthood is a dream for many people. That dream can be achieved in a variety of ways. Some people, like my wife Caitlin and I, need to turn to help from medical professionals, and New Hampshire has been a leader in this area to protect children born through assisted reproduction. This bill will allow parents, all parents, including those who have become parents through assisted reproduction, to use a simple affidavit to affirm their parental rights, as opposed to having to go through a full confirmatory adoption application and hearing. This allows granite staters to use our judicial system most efficiently, as well as feel our rights are protected in a simple, easy-to-use way. I know this process firsthand, as I adopted both of my older daughters and will have to adopt my third, though I carried and gave birth to them, because that is still the advice for same-sex couples. This bill would open a more efficient route to families like mine. This bill is similar to, but a step forward from the work done on Senate Bill 264 FN from last year. There is always more work to do, and I appreciate my friend Senator Carson continuing to move forward on this important issue. Thank you for your time and your consideration of SB 422. Senator Rebecca Perkins Quokka, Senate District 21.
Thank you.
Thank you.
And we'll submit that into the record.
Do you have? Good afternoon, Madam Chair, members of the committee. My name is Christine Hanisco. I'm an attorney here in Concord, New Hampshire. I'm a mother through assisted reproduction, and I'm an unmarried parent. Unlike Senator Perkins Quokka, however, my family had the access to a voluntary acknowledgement of paternity form. Nobody at the hospital questioned whether my partner was the father because he presented as male, and he is male. We were able to secure our twins' parentage immediately upon their birth. That was one of the first forms we filled out after they were born. Their birth certificate came in the mail later that month with 2 names on it. We are not trying to create new types of parents. These parents already exist. And as you will see in my written testimony on page 2, as a result of the most recent census, 35% of all unmarried parents live together with their children. These families exist, the numbers are going up, and we need to protect them all. Children are entitled to insurance, they're entitled to support, love, caring, but this financial piece can only be secured through these forms. Many of our families cannot afford the court process, and many of them don't even know it exists for them. So while I do have the privilege and honor to go to court, thanks to the work of this legislature, which recognized the need for confirmatory adoptions in 2020, those families are limited. There are many more who don't have the resources to hire me and who don't have the understanding of the process to do it on their own. So I would ask that you support this bill, and if you have any questions, I'm happy to answer them, as I am one of the people who was involved in the drafting.
Thank you very much for your testimony. Are there any questions? Seeing none, thank you.
Thank you.
The chair will call Patience Crozier. Good afternoon.
Good afternoon, Chair and Committee. My name is Patience Crozier, and I'm here to testify in support of SB 422. I have for decades been a family lawyer like Attorney Hanisco, and one thing is clear to me through those decades of practice, which is the legal parent-child relationship is the single most important thing for children and the foundation of their stability and well-being over their lifetime. And that is because, as the chair said, it is a source of so many rights and benefits for children, from health insurance to child support, inheritance rights, decision-making. It is really the foundation. And you either have it or you don't. And it makes children vulnerable when they do not have that. I think this bill is so incredibly important because it opens up a procedural route that really provides greater protection for children. Again, it's not doing anything new. It's just opening the door for people to sign this form in the hospital like all other families. I've represented a lot of people who've actually experienced being in a hospital and not being able to have that experience of signing a form, and feeling unequal, feeling scared, feeling like they have to wait and go to court and spend money and wait for months to have their child be protected. And this is just a game changer. It's, day one, you can protect your child in the hospital like everybody else. It is just incredibly important. And, I think it's aligned with federal law. It's aligned with really what other states are doing. And honestly, it's just more efficient, right? We don't want folks going to court if they don't have to. It's just better to be part of the system that protects other children. As the chair noted, this is already law in 11 states, and it's currently pending in another number of other states, including Minnesota and Michigan. So I think it's a very common sense piece of legislation, so incredibly impactful to the children of New Hampshire, and I'm happy to answer any questions.
Thank you very much for your testimony. Are there any questions for Ms. Crozier? Seeing none, thank you very much.
Thank you.
Okay, the chair will call Catherine Tucker. Good afternoon, Ms. Tucker.
My name is Catherine Tucker. I'm also a lawyer like Attorney Hanisco. I practice out of Loudon. And Senator Carson, I really appreciated hearing you talk about how it's important to secure parentage for unmarried parents efficiently and soon after birth. And I want to talk about a situation where that did not happen. And this is clients of mine who unfortunately were not able to be here today, but I do want to read a portion of their written testimony, which I just handed around. I wanted to share our story of creating our child. Katie and I are a same-sex couple who have been together for over 9 years. We own a home, we own a dog, together we travel the world together. We decided 3 years ago that we wanted a child together. So we started the process, which is a very expensive process right from the beginning. We chose, after much deliberation, thought, and research, a sperm bank out of California. We chose the donor. Katie was inseminated multiple times. Finally, after 6 tries, Katie became pregnant with our son. It was a joyous moment for us when the pregnancy test came back positive. Then the 9 months was filled with all of the fun that comes with pregnancy and preparing for a new life. Hudson was born in November. He was born with his eyes wide open, already curious about the world around him. Katie and I cried hard, tears of joy. He was finally here. On day 2 of his life, my world was rocked. A woman came in to take his name and prepare his birth certificate. Katie was not in any form to fill out the form, so I did it. Filled in his name, Katie's name and social, and my name and social security number. We signed it and gave it back to her. She looked at me as I gave her the form. She asked very deliberately, "Are you 2 married?" without even looking at the form. I said no, but we have been partners for 7 years. She took the form and said, "You'll need to fill out a new one with just Katie's information on it. You cannot be on the birth certificate. You're going to need to fully adopt him, as New Hampshire doesn't allow 2 mothers on the birth certificate." She was very curt, cold, and unsympathetic. And when she left and was like, "I will collect this document in a little while," I went into the bathroom, shut the door, and had a complete meltdown. I did not want Katie or Hudson to see me in that state because it was day 2 of Hudson being alive and Katie being a new mom. But that moment was life-changing for me. I was told that I wasn't his mother, and it was going to be a long process for me to become his mother, even though I loved him from the moment he was created. After that, I went home, obviously a lot of sleepless nights with a newborn, and I started researching New Hampshire adoption laws for same-sex couples. It was convoluted and none of it made sense, because in my mind, it should be so easy. Katie and I made a baby together. We both love him the same amount. We both financially care for him in the same way. There is nothing separating what her and I do or feel for him. Yet she is considered his mother, and I was not. I struggled through the first year of his life due to this hanging over my head, and nowhere was I listed as his mother. I could not call and make appointments or ask for his medical records because I was not listed on his birth certificate. If I wanted to travel with him alone, it was a scary thought because I had nothing saying he was mine. I found an attorney, Catherine Tucker, and I reached out and she responded immediately, willing to help. I was appreciative and thankful, but also scared because the thought of the financial responsibility of a newborn, along with navigating all of those attorney's fees and court fees, was overwhelming. It took me a while to work up to be able to take that next step. And then eventually they were able to secure her parental rights also, but she writes, "I go back to that day in the hospital room where if I were a man in that room with Katie, and as a man, I filled out the forms, but I had no biological connection to Hudson, and I was not married to Katie. As a man, I would have been immediately accepted as parent number 2 on the birth certificate, because that woman never would have asked if we were married or if I was the biological father. It never would have been assumed. It pains me. I humbly ask that you reconsider how same-sex couples are treated with regard to their legal right to their children upon birth. I can't imagine if anything happened to Katie in those first 2 years of Hudson's life. Hudson could have gone to foster care, even though he had a mother who loved him. It was a very scary place." And I'll just share that this is not an isolated situation. This is what these families are looking at. And so I thank you for considering this bill.
Thank you very much for your testimony. Are there any questions? Before you go, I'm going to ask Attorney Hanesco and Attorney Crozier to come back because I have a question. And for you, I forgot to ask it while you were up here. So if the 3 of you can come back up, I'd appreciate it. You can pull another chair up. Thank you again for coming forward to answer my question. We've heard about the beginning of the process, how important it is to establish parentage. What happens to a same-sex couple that doesn't have access to this form if at some point down the road they decide to separate or get divorced? Can you speak to that situation?
So at that time, they could bring a parentage action. Our current laws, again, updated as most recently as last session. This is, I think, the third bill in a series, so to speak, since 2020 that have addressed these issues. The reason this one came last, I'll come back to your question. The reason this one came last is because of the complexity of the number of statutes that are implicated, because it's both vital records and the Bureau of Child Support. And we've been having conversations with those entities for a number of years. So what would happen would they have to bring a parentage action at that time and litigate it in our courts. So if they're not married, the non-genetic parent would potentially and hopefully be considered a parent through our holding out statute because they've been raising the child. Everybody knows them to be the parent. But again, this is going to be a court process. It's not going to be just by agreement. And I'll let either of my colleagues jump in beyond that. But again, it's going to be expense that many people don't have access to the costs. As I'm sure members of the committee are aware, we have a crisis in the state. Every family law attorney I talk to that does marital cases and parenting cases is overwhelmed. They're turning cases away, and that's for people who can pay. We have many, many more who can't. And although we have the pilot programs now in a couple of our courts, that's still a huge unmet need and lack of access to justice.
Okay. I'm sorry, please. Yep.
That's such a great point that like with a VAP, the issue then just becomes figuring out the custody and parenting time. It does not become the issue of parentage.
Right.
And I would just say for folks New Hampshire families who might move outside of New Hampshire that doesn't have as good laws as New Hampshire, that non-biological parent might in fact not be recognized as a legal parent and might lose a relationship with their children. So like that port in this kind of mobile society, having that protection in New Hampshire really protects them in other states as well.
Okay, thank you. Senator Abbas has a question.
Thank you, Madam Chair. I understand the issues if there were a divorce filed. What about any estate issues? Would that come up as well?
So it would, by securing the legal parentage through the VAP, it will allow that child to inherit the same way from their non-birth parent that it does from the birth parent. And the family at large, right? Grandparents, aunts, uncles.
Thank you.
Okay, are there any further questions? Seeing none, thank you very much for your testimony.
Thank you, Madam Chair, and thank you for bringing us back up.
Are there any other member of the public who would like to come forward to speak to Senate Bill 422? Okay, seeing none, I'm going to close the public hearing. And before, I'm going to put the committee in recess till 3:30, but I would like to take this opportunity to thank my fellow committee members. Our committee had the assignment of hearing 64 bills since January. And I would like to thank them all for hanging in there because we just heard the last bill that we have received. We do have a couple more that were filed late, but we can take care of those later. But I want to thank you. We had a very, very aggressive schedule, and we've had all of our public hearings in just about a month. So I really want to thank them for doing all of this work.
And thank you, Madam Chair.
Okay, so the committee will be in recess until 3:30. I'll give everybody time to go. Okay. The committee will come out of recess. Can I get a motion to enter into executive session?
So moved.
So moved. Okey-doke. Thank you, everyone. The first bill that we are going to take up is CACR 24, and I will, okay, Senator Gannon moves IPL, seconded by Seconder Abbas. Is there any discussion on the bill?
Yes.
Okay, Senator Whitley.
Thank you, Madam Chair. I cannot support the ITL. I was really hopeful that we would be able to send this to the voters. I mean, I think it was pretty clear. I think we all know a CACR, we're not voting on the substance. All we are doing is voting to send this to our voters. And I think our voters are really asking for this. We heard testimony that 87% of voters want to see New Hampshire protect their right to abortion in the state constitution. Our voters want to see this. And so I understand that people may not support the substance, but I really thought it was time to send this to the voters, particularly when we know since the Dobbs decision, 6 other states, including fairly red states, have sent this to the voters. So I'm disappointed. I mean, we have a long and bipartisan history of supporting privacy, particularly when it comes to medical decisions. Our voters care about privacy. You know, there was a privacy amendment that went to our voters several years ago, and you know, I personally think I think we should trust our voters. I trust women and to make decisions. I think this is clearly about whether the government should be able to intrude on deeply personal medical decisions. And I would think that the members would want the public and our voters to weigh in. So I'm disappointed that we don't trust our voters enough to send this to them.
Okay, thank you. Are there any further comments? Senator Chandler, you look like you want to say something.
Yes, thank you, Madam Chair. Senator Whitley has summed up my feelings for the most part on this constitutional amendment concurrent resolution, in that I do wish, I think it's very important that we recognize that all persons should have the right to make their own reproductive decisions, and allowing it to go to the voters would have been a way to determine that that is the will of New Hampshire citizens.
Okay, thank you very much, Senator. Senator Abbas, do you have something you wanted to say? Nope, okay. All right, is there any further discussion on the ITL motion on CACR 24? Okay, seeing none, all in favor say aye. Aye. Any opposed?
No.
Okay. Senator Gannon, would you like, okay. Okay. Next, we're going to take up Senate Bill 575. Okay, Senator Gannon moves ITL. Senator Abbas moves seconds. Okay, are there any comments? Senator Whitley.
Thank you, Madam Chair. I'm disappointed. I think that we didn't hear from our colleagues about why they didn't support the prior bill. Hopefully they'll speak to their motion in this case. I think this bill is another important one, particularly in the wake of Dobbs. You know, this is really important because we know that anti-abortion states are reaching into states with more positive abortion access. And so I think it's really important to protect individuals who provide, obtain, support abortion care in New Hampshire. I think we have an obligation to protect them if we are going to say that we are a pro-choice state. You know, we heard from providers, and they said to us, it's really not hyperbolic. They are scared. And this seemed like a very common sense measure, and I'm really disappointed we can't support it.
Okay, thank you. Are there, Senator Chandler?
Thank you, Madam Chair. I think one of the things we know is that states that have the greatest number of restrictions on abortion care and reproductive care also tend to have the highest rates of maternal mortality. That in itself is problematic and not something that this bill would necessarily address that issue, but it would provide for folks in those states to be able to come to our state if if they need to access healthcare here. There's incredible inequities in healthcare, and this bill would have allowed folks who access healthcare to do so without potential repercussions from.
Thank you, Senator. Are there any further comments?
Yeah,
Senator
just
Adams?
briefly, there was no precedence on, on any subject showing that any conduct in the state of New Hampshire, especially if someone never been to the other state, would ever be prosecuted under the other state's law. They've never stepped foot there. I know we heard some testimony of that, but there's no legal precedence for that at all. And that, along with the conflicts in law that this creates, can't support it.
Okay, thank you, Senator. Are there any further questions or comments? Okay, seeing none. We have Senate Bill 575 with an ITL motion. All in favor say aye. Aye. Any opposed?
No.
Okay. Senator Abbas, would you like to take this one?
Yes.
Okay. We are not going to take up Senate Bill 461 at this point in time. There's discussions ongoing about that one. So it is not a fiscal note bill. So we're going to hold that one for a little while longer. The next one that we have is Senate Bill 567. And I'm going to make the motion of ought to pass. I have an amendment that I'd like to present. Everyone should have it. We have amendment number 0469S, which establishes a study committee to look at this. And the reason why is because this is currently a case in front of the Federal Supreme Court of the United States. And I would hate to go ahead and pass a law that is going to conflict with whatever they come up with for a ruling. So hopefully it's my understanding that the Supreme Court should be issuing a ruling sometime this spring, and it'll give this study committee the ability to actually look at what the Supreme Court has said and to look at our existing state laws as well. So I'm just bringing forth amendment number 0469S. Are there any comments or questions about the creation of a study committee?
Was there a second?
Oh, was it, I thought Senator Gannon did. Okay. Yes, Senator Whitley.
I also have an amendment.
Well, let's see if we can take them up one at a time.
Well, no, I know, but it's relevant to the conversation because I, recognize the need to, think about this issue in the context of the ongoing Supreme Court decision. And I think having DHHS do the necessary work is really critical. I think a study committee, we're not the experts, DHHS is. We're going to need to be prepared when this decision comes down one way or the other. And it's DHHS who holds this information. It's DHHS who has the expertise. And so I would rather them be authorized to be ready to respond in any way that's really necessary. They're the ones that know our healthcare delivery system. They're the ones that need to identify the gaps. They're going to be the ones that are going to deal with the impact of the decision. So it should be DHHS. Of course, we don't want them to do anything that would violate state and federal law, which is what my amendment was going to do. DHHS said very clearly, I sent it to them. They say they don't see any conflicts with their current work and federal funding with my amendment. I also think this amendment doesn't even mention the word abortion. We're talking about medication abortion. This amendment doesn't even address it. And the only duty it does is to just study the availability when we're asking DHHS to do more than that. We're thinking about access. We're thinking about gaps. So it doesn't even address what we need them to do. It would be sort of a waste of our time. Furthermore, we only have one senator on that. This is an issue that I care deeply about, but not every senator supports access to abortion, even earlier in pregnancy. We know this. So I have no assurance that we will have the adequate people on this, that it won't be a politically driven process when we're talking about medical care. So I absolutely can't support this amendment. I thought we had a bill that, tracked with our history. I mean, the New Hampshire was one of the first states that in a bipartisan way said we need access to mifepristone. This is an incredibly safe drug that has broadened access, reduced inequalities. This bill, as originally formed, is even more necessary. Our Attorney General just recently failed to sign on to a brief that all our neighbors did that basically says that, the Fifth Circuit, that decision cannot stand, that this is an important drug. All our major medical organizations submitted an amicus. Our neighboring governors did. We need to do something to protect access to mifepristone in New Hampshire. If we are a pro-choice state, we talk a lot about, that issue. We need to actually do something affirmatively. Our governor hasn't done something affirmatively. We as a legislature need to affirmatively make sure that our constituents, all grantees can access the care that they so desperately need. Mifepristone has been made political. It's not political. It's part of reproductive health care, and DHHS has a role in this to make sure it's not political. So I truly hope we can vote down this amendment so I can bring forth mine.
Okay, thank you. Other Senator Abbas.
Thank you, Madam Chair. I'll just point out that even this policy aside, once the Supreme Court makes a decision, whether the bill even as amended, it can become stale. So even before it's signed into law, if we get that far. So there's a lot of uncertainty. I think having the study commission, it keeps it alive, the legislation. And it allows us to react to what happens at the federal level. I think doing anything before that comes out is just be irresponsible.
Are there any other comments? Okay. Seeing none, we're voting on amendment number 0469S. All in favor say aye. Aye. Any opposed?
No.
Okay, passes 3-2. Senator Whitley did discuss her amendment, which is amendment number 0073S. Are you making a motion? Oh, no, it doesn't matter. Okay, doesn't, okay. So we have the motion of ought to pass as amended. Is there a second? Okay, just want to make sure we're touching the right bases. Okay, so we have a motion of ought to pass as amended. Is there any further discussion on Senate Bill 567? Okay, seeing none, all in favor say aye. Aye. Any opposed?
No.
Okay, and I will take this one out. Okay. Okay. Next, we are going to take up Senate Bill 360. Okay, we have a motion of ITL by Senator Gannon, seconded by Senator Abbas. Is there any discussion? Yes. Yes, Senator Chandler.
Thank you, Madam Chair. I think I will not support an ITL of this piece of legislation, which we've seen we've seen several versions of it, and this one is important. It does so much to help protect the people of our state. The support was strong from so many people who deal with the issues that that we hope to address in this bill. We are trying to address mental health issues and protect the people of our state from harming themselves or others, when in fact it is very narrow, the bill is very narrowly drawn so that only certain people could make this kind of report and have it be acted on. I think it's important for to address safety in our state, and I am saddened that that there isn't greater support for this bill.
Okay, thank you. Senator Whitley?
I also can't support the ITL because we talk a lot about public safety in this committee. This is a public safety bill. This is gonna save lives. We also know it's a suicide prevention measure. We know that annually in New Hampshire, 124 people in New Hampshire die by suicide with a gun. 124 people. Right? DHHS has said that for more than 10 years, New Hampshire has had a suicide rate above the national average. Don't we have an obligation to address that? Don't we have an obligation to save lives? This will do it. We heard from NAMI, we heard from the Medical Society, we heard from the Psychiatric Society that this is a common sense policy that will save lives, improve public safety, and I feel like we have an obligation to move it forward. Thank you.
Thank you, Senator. Are there any any further comments on the ITL motion? Okay, seeing none, all in favor say aye. Aye. Any opposed?
No.
Okay, I will take this one out. Okay, the next one that we have is Senate Bill 571. Okay, Senator Gannon moves ITL, Senator Abbas seconds. Okay, is there any discussion on the ITL motion of, on Senate Bill 571? Senator Whitley.
So this is another one where like we have to listen to our voters. Again, 85% of Granite Staters support a measure like this, background checks for all gun sales. Why aren't we listening to our voters here? I mean, I think this is a very responsible measure. No one wants firearms from reaching individuals who by law should not possess them. That's what we're talking here. We're talking about making sure that only people who are legally allowed to have access to firearms. Why wouldn't we support something like that? It's really baffling to me.
Okay, thank you. Senator Chandler?
No, thank you, Madam Chair.
Okay, I noticed just the red light was on. I thought you wanted to speak. Are there any further comments on the ITL motion? Okay, seeing none, all in favor say aye. Aye. Any opposed?
No.
Okay, Senator Gannon, would you like to do this one? Okay. Next, we have Senate Bill 577. Okay, we have a motion of ITL moved by Senator Gannon, seconded by Senator Abbas. Is there any discussion on the ITL motion? Senator Chandler?
Yes, I oppose the ITL motion on this bill. Again, this is a bill that would be an important step, again, in suicide prevention, something we know that our state is certainly no less susceptible to the ills and horrors of suicide and than any other state, and we need to take measures to address that. This bill would strike a balance between allowing folks to purchase firearms and help making sure that we are doing everything we can to protect public safety.
Thank you very much, Senator. Senator Whitley?
Yeah, I mean, again, we sat through a lot of testimony. We heard a story from a mom of a 21-year-old who died by suicide after getting a gun after 30 minutes. I don't understand why we aren't willing to take any measure to protect life, We are hearing from our experts, our medical providers, NAMI. These are measures that will help save lives. So I won't be supporting the ITL.
Thank you. Are there any further? Senator Abbas?
I understand the motivation behind this is one thing, but the computation of time of when the 3 days would go by and all the list of exceptions, there was a lot of flaws with just many of those exceptions that made this just not operable, at least reasonably enforceable in reality. I mean, talking about when the police, did the police determine you reasonably fear for your safety? Does the person, the firearm, licensed firearm dealer have to make the determination? There's a lot of those kind of pitfalls that just made this, it needs a lot of work. It's not ready to even be considered beyond that point.
Okay, thank you. Are there any further comments? Okay, seeing none, we have an ITL motion in front of us that's been moved and seconded. So all in favor, say aye. Aye. Any opposed?
No.
No. Okay. Senator Abbas, would you like to take this one out? Okay. Okay, next we have Senate Bill 322. We also have an amendment for Senate Bill 322, which has been submitted by the bill sponsor. Is there a motion? I will move on to pass, seconded by Senator Gannon. So I believe that this amendment addresses some of the, an issue that came up during the public hearing. I was not here during the public hearing. I was gone for another, I had to introduce a bill. So we're just going to put forward amendment number 0057S. So we have a motion of ought to pass. Is there any discussion on the ought to pass motion on Senate Bill, the amendment 0057S? Senator Chandler?
Thank you, Madam Chair. So, you know, I am somewhat torn on the amendment. I believe that the bill is looking to have things two ways. That we do not want a permitting process for concealed carry in our state, but we are saying to our police that you must issue permits without a cohesive process in place. So my concern is that I understand why law enforcement, members of law enforcement have been reluctant to sign with their title and signature, their name and title and signature on a permit that they don't feel that they can they may not feel comfortable authorizing. The amendment, I think, I understand the desire to give them immunity if they're being asked to do something that they're not comfortable doing. But that to me points out the flaws in having a permit without a permitting process in place. I may vote for this amendment because I think that I understand the need for it, but I cannot support SB 322.
Thank you. Are there any further comments or questions on amendment number 0057S? Okay. I thought Senator Gannon did. Okay. Okay, so we have an ought to pass motion on amendment number 0057S. Are there any further comments? Seeing none, all in favor say aye. Aye. Any opposed? Okay. Is there an ought to pass as amended? Okay, Senator Gannon moves ought to pass as amended. Senator Abbas seconds. Okay, are there any further comments on Senate Bill 322? Senator Chandler?
Yeah, and at the risk of repeating myself, I do think this bill now as amended really is not good policy. We are charged with creating good policy, good product, and our legislation is the product we produce for the state of New Hampshire. And again, I don't believe that it is wise for us to require police departments to issue permits when there is not a permitting process in place for everyone in the state. And I think to then give them immunity, it just seems to me not a good way of creating legislation. So I can't support 322.
Thank you. Are there, Senator Whitley?
Yeah, I mean, this is kind of like an anti-public safety bill, in my opinion. Our chiefs told us they don't want to certify these permits by signing, especially when they know that a particular individual shouldn't have a gun. So the folks in charge of public safety are telling us they don't want to do it, and now we're going to force them to do it? It doesn't make a whole lot of sense to me.
Thank you. Senator Abbas?
Thank you, Madam Chair. the Supreme Court came out with the case, I believe in June of 2022, that when it came to the permits and the licenses for firearms, they shall issue, is basically that sums up a very long holding in a short sentence. So at this point, unless there's a reason why it should not be issued, meaning the person's disqualified under federal law or any existing state law, they have to issue the permit. That's the current law of the United States, in all 50 states. So.
Okay, thank you, Senator. Senator Whitley?
Yeah, they are issuing them. It's not like they're not issued. There was not one iota of testimony saying that these permits are not being issued. They are being issued. But the Supreme Court, no Supreme Court that I'm aware of has said that in addition to issuing them, they have to sign. So I have to push back on it.
I think the issue is out of other states, when you go out of state with them, when you have reciprocity, aren't going to honor them if they're not signed. And that's the problem. So you can be in Maine or Vermont, or, I don't know every state we have reciprocity with, but that's where you're going to run into some trouble. Not in the state of New Hampshire, you're fine. So you don't want to be in Maine and all of a sudden be violating Maine's law because it wasn't signed. So that's what we're trying to avoid have happen.
Are there any further comments, questions? Okay, we have an ought to pass that's been moved and seconded. So, all in favor say aye. Aye. Any opposed?
No.
Okay. Senator Abbas, would you like to take this one as well?
Yes.
Okay. Okay, we have one more that we're going to take up this afternoon, which is Senate Bill 421. And Senator Gannon moves interim study. Is there a second?
Second.
Okay, second. Well, Senator by Senator Whitley. Okay, is there any discussion on Senate Bill 421? I think that I'll just say something. I think that this bill needs more work. That's why the interim study, it's kind of convoluted and complicated, and it's just at this point in time today, it's not ready to come forward. Senator Chandler?
Yeah, I would agree with that. I think that the situation described was not that was described as the impetus for this bill was a terrible situation, and it appears that there was really a problem with charging, not necessarily I don't think this bill addressed the problem. So thank you. I think that interim study is appropriate.
Okay, so we have an interim study motion that's been moved and seconded. Is there any further discussion on the interim study? Okay, seeing none, all in favor say aye. Aye. Any opposed? Okay, is there a motion for consent?
Motion for consent.
Okay, Senator Gannon moves consent.
Second.
Seconded by Senator Whitley. Is there any further discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, and I will do this one, just a little blurb. Okay, that concludes the bills that we are going to take up today. I am working on a list because I'm going to try to get for us to exec 17 bills next Tuesday and the following Tuesday, and I'm working on a list. So much like we gave our committee members a list of what we were going to be execing, just because we have so many of them, so that way everyone can be prepared before we exec. So again, thank you very much for all your help, and we are done. Oh, I need a motion to come out of executive session. Moved by Senator Gannon, seconded by Senator Whitley. All in favor say aye. Aye. Okay, we're done for the day. Thank you very much for all your help. Okay. Okay, I haven't heard a word. Ugh, drives me crazy.
Good luck tonight, Chair.
Oh, thanks. Yeah, I gotta head up to the hospital, so. Oops, I gotta do